this bill to the House.
The question is that the motion be agreed to. Honourable Phil Goff.
Mr Speaker, the Labor Party supported this legislation at the first reading, and the reason that we did that was that we are prepared to support any reasonable piece of legislation that actually promotes the rights of victims. I'm very proud to stand here as a member of the Labor Party that brought in the first Victims' Rights Act back at the time of the fourth Labor government, and I extended that as Minister under the fifth Labor government. We do have to remember that the justice system is not simply the state against the offender, but the victim has a right to be at the centre of the justice system and to be respected and to have their rights upheld. And that has not traditionally been the case under our system of justice. Mr Speaker, this bill was brought into Parliament because there was a gap in the protection that was accorded to victims. We had the Domestic Protection Act of 1995, and that enabled the granting of protection orders for those who were the subject of domestic violence. But not all acts of violence, of course, are domestic. For those that were being actively harassed by people who had offended against them, there is the Harassment Act of 1997, and that also can provide restraining orders. But there was a clear gap in that system where the offender against the victim was not related to or known to the victim, was not actively harassing them, but was causing trauma to the victim. And the actual case that led to this, Mr Speaker, will be of interest to you because it comes from Invercargill. And it was the case of a woman who was the victim of rape. The offender was sentenced to 4 years imprisonment. He was then released, and he went from prison and moved immediately next door to the victim that he had raped. Now, anyone in this House or anyone in the public can imagine the trauma of being the victim of rape and finding that then, released from prison, the rapist is living immediately next door to you. And that was unacceptable, it was not tolerable, but there was no mechanism under law to deal with that situation and say the victim has rights in this situation, and those rights are stronger than the rights of the offender, even after the offender has been released. Now, when I read about that case, I agreed that there was a gap. And then I looked at the bill that Judith Collins had introduced, and to my absolute amazement, Mr Speaker, I found that her bill, full of rhetoric, had no substance that would have provided one iota of protection to the very victim that led to this bill being introduced. And that is because the Minister put a threshold level of 5 years. You had to be imprisoned for more than 5 years, or convicted and sentenced to more than 5 years, before the victim of your offending could get any protection under this Act. Imagine how your constituent, that victim, felt when she saw a bill and realised that this would not only not help her, but it wouldn't help countless dozens of other women that had been through the same experience of her as she had. And that was utterly unacceptable. When I read the regulatory impact statement, I found that this piece of legislation, introduced with great flourish, would protect 10 cases a year. 10 cases. We're talking about offending that's running into hundreds and hundreds of cases, and it wasn't good enough. And I said in the first reading of this bill is not acceptable in the form that it is. It needs to be strengthened. That threshold has to come down. And there was a very fortunate act of God, well actually it was an act of Air New Zealand, that helped me promote my case. Because just a month or two ago I found I was sitting next to the Minister of Justice. And she was thrilled to see me, of course, Mr Speaker, and we had a very good conversation, and I raised this issue with her. And I made the point to her quite strongly. I said, look, 5 years is stupid. Your officials are coming back, and your members of Parliament on the committee are coming back and saying maybe 3 years. These are arbitrary figures. They're plucked out of nowhere. They have no rationale. I said that the figure should be 2 years. It should be 2 years because under the Parole Act 2002 that I put through, 2 years was the definition of a serious criminal offence. where, people were entitled to go on victim notification registers and so on. And to be fair to the Minister, she acknowledged the inadequacy of the bill and she agreed that that change should be made. So I'm very happy to report back to the House today, Mr Speaker, that the threshold level is 2 years, and I believe that that is an appropriate level of protection, and it will involve a whole lot more people and provide a lot more real protection to victims that genuinely need that protection when placed in the same situation as your constituent. There is a couple of other changes that I wanted to see and that I'm very pleased that, that we have got put into this bill at this stage. The second thing was in the bill as introduced that I thought was inadequate was that you could apply for a non-contact order. Well, Jackie Dean knows that because she knows who moved the amendments in the committee and how the discussion went. So I hope that she'll get up and affirm the accuracy of everything that I'm telling the House today, which she will do because there were 7 different witnesses as members of Parliament on that committee. The second thing was, and again it was a concern for me at introduction, was that you could not apply for a non-contact order against the offender until the offender was released. Well, we heard before the Select Committee, Mr Speaker, of cases where the offender in prison, even against all of the rules of the Corrections Department, was putting pressure on the victim while he was still in prison. And of course, there's no such thing as a non-contact order under this bill to cover that situation because you could only apply for it after the person was released. Well, first of all, the Department of Corrections should have stopped that and stopped it dead in its tracks. It was totally inappropriate. But secondly, this provides another protection because from the moment of sentencing, now the victim can apply for a non-contact order. And there's a second thing that makes sense out of that, Mr Speaker. In the situation where the offender is released, there can be a gap between the offender being out in the community and the victim having to make application and a decision being made. So there's a gap there still where the offender can quite lawfully approach the victim, a victim of his serious offending. And with the contact order now able to be applied for any time after sentencing, we can remove the situation where a gap exists and where protection will occur from the moment the person steps out of prison, as well as, of course, the additional protection while the individual is still in protection. So we got changes on the threshold, which are good, and I think the whole of the committee actually welcomed that change. We got changes so that you could apply for the non-contact order at any time after sentencing. And the third thing that I think was important was dealing with where the offender used an associate to make contact with the victim. So the offender was using one of his mates as a surrogate for him to contact the victim, and the effect on the victim was just the same. She was under pressure because the offender was using a third party to approach her and contact her quite inappropriately. So we now have in this legislation a situation where an associate of the offender can have a non-contact order made out against them. And there are 3 prerequisites to that. First of all, the offender needs to have engaged in the behaviour of actively encouraging the associate to do it. The associate needs to have engaged in the behaviour of doing it, and there needs to be a demonstration that that affects the well-being and the recovery of the victim. So that is the third change that is quite important. One other issue that I raised, and I know my colleague Andrew Little also raised this, was the question of, under the non-contact order, isn't this putting all the pressure on the victim to have to take all the action to protect usually herself against the offender? Well, I raised that in the committee, and the officials were adamant that there would be a very straightforward and relatively cost-free way in which the victim can achieve a non-contact order. But I'd very much like to hear from government members, because the Minister did not include this in his speech, that we have the assurance that a person will be able to get these contact orders without the need for legal assistance, and that there won't be costs imposed on the victim. The victim, for example, shouldn't have to pay a filing fee for a non-contact order, and I'm not sure whether we covered that in the Select Committee, but I'd like an assurance from the next National Speaker or from the Minister that those sort of costs won't be imposed. With that, Mr Speaker, I think we made considerable improvement to this bill. It's now a worthwhile piece of legislation, and we will be supporting it through the remainder of its passage into law.
Jackie Dean.
Thank you, Mr Speaker, and I can tell the member who has just resumed his seat that the Honourable Judith Collins was more than delighted to spend an hour with the member on the aeroplane. And it is lovely that he's chosen to take credit for every change that the select